Good afternoon. I'm Bill Bratton, a co-director of the Institute for Law and Economics. It's my great honor this afternoon to welcome Governor Daniel Tarullo of the Federal Reserve Board to Penn Law and to introduce him to you as this year's Institute for Law and Economics Distinguished Jurist Lecturer. In so doing, I note that most lecturers in this series have been judges. I also note that we have in the past interpreted the concept of jurist capaciously so as to hear from prominent lawyers who were positioned to make particularly important decisions for one reason or another. Still, Governor Tarullo is the first regulator to take this podium, and not just any regulator. Governor Tarullo is a Fed. So much so that he is accompanied here today by an officer of the U.S. Federal Reserve Bank Police. Please note that no interpretive contortions were needed to support our distinguished jurist invitation, for Governor Tarullo is a Fed with a uniquely juridical background. It's true that he started out after law school in the Clinton administration, but he soon enough was on the faculty of the Harvard Law School. But he then went on to the role of government official with a legal academic past, working as a special assistant, working as chief counsel for employment policy on the staff of Senator Edward Kennedy. He then joined the Clinton administration in 1993 as Assistant Secretary of State for Economic and Business Affairs, going on to become the Deputy Assistant to the President for Economic Policy, and finally to serve as Assistant to the President for International Economic Policy. While all that was going on, he was a principal on the National Economic Council and the National Security Council and the President's representative to the G7 and the G8. When the Clinton years closed, Governor Tarullo reversed roles, becoming a legal academic with a past as a government official upon his appointments as professor of law at Georgetown and as visiting professor at Harvard Law and at Princeton. He simultaneously served as a senior fellow at both the Council on Foreign Relations and the Center for American Progress. Thus, back in the academy, he made a unique contribution as that rarest of law professors, one who actually knows something about economic policymaking. And he did something else. Back in those days, law professors with economic inclinations did governance. Or they modeled things, or they did empirical studies, generally devoting themselves to the cause of unleashing beneficent free market forces. Governor Tarullo alone, in the legal academic crowd, studied a regulated financial industry, banking, in particular, bank capital regulation, an academic endeavor in which he was joined by only a handful of people in business school finance departments, mostly across the street here in Philadelphia. Governor Tarullo wrote a critical, provocative book called Banking on Basel, which came out in 2008. We all know what happened immediately after its publication. Those events brought about another role reversal for Governor Tarullo, who once again became a government official with a legal academic past when he took office at the Federal Reserve Bank in January 2009. He's been serving in what one might call interesting times, and comes to us today to talk about financial stability regulation, a subject on which he is beyond expert. It's my privilege to give to you Governor Daniel Tarullo.
Thanks, Bill. And it's good to be here at Penn this afternoon with Amtrak running on time today, I'm pleased to say. Even with the generous amount of time that the Institute for Law and Economics allocates to this lecture, what I wrote beginning actually over the summer turned out to be too long. So I've cut about a quarter to a third of the prepared text in order to fit, roughly at least, within the time you've allocated today. But by now there should already be up on the Fed website the full text of the remarks that I did prepare beforehand. Now, as one would expect of a piece of legislation that has 16 titles and runs 849 pages in the statutes at large, the Dodd-Frank Wall Street Reform and Consumer Protection Act ranges widely in addressing problems both directly and indirectly associated with the financial crisis. Taken as a whole, though, the primary aim of those 849 pages can fairly be read as a reorientation of financial regulation towards safeguarding financial stability through the containment of systemic risk, phrases that both recur dozens of times throughout the statute. The law, explicitly in many provisions and implicitly in many others, directs the bank regulatory agencies to broaden their focus beyond the soundness of individual banking institutions, and the market regulatory agencies to move beyond their traditional focus on transaction-based investor protection. This emphasis on financial stability and systemic risk is hardly surprising in light of the damage done by the financial crisis and the ensuing Great Recession, from which we continue to recover only slowly. Indeed, concern about financial stability and systemic risk has at times been a crucial impetus for financial reform in the United States. Much of the New Deal legislation that defined the financial regulatory structure for more than 40 years was in direct response to what we would today call systemic concerns, including banking panics and excessive leverage in equity markets. 20 years before the New Deal, the creation of the Federal Reserve had been intended at least as much as a financial stability measure as an instrument of monetary policy. But seen in the light of more recent history, Dodd-Frank represents something of an about-face for financial regulation, which had largely neglected systemic concerns in the decades preceding the crisis. The Sarbanes-Oxley Act of 2002, while far-reaching in many respects, was very much a traditional piece of securities legislation, insofar as it focused on investor protection. Banking law reforms enacted after the 1980 savings and loan debacle had traces of concern with financial stability, but the emphasis was still on the regulation of individual depository institutions. Most other banking law changes of the 1980s and 1990s, culminating in the Gramm-Leach-Bliley Act of 1999, were essentially deregulatory. These laws, along with the administrative actions that both preceded and implemented them, removed many restrictions on activities, affiliations, and the geographic reach of commercial banks, without substituting new regulatory mechanisms to control the institution-specific risks that could arise from the growth of financial services conglomerates, much less the systemic risks created by the rapid integration of capital markets and traditional lending activities. By the time financial stress began rising rapidly in the second half of 2007, systemic risk and financial instability had come to seem more theoretical than real to many regulators, academics, and financial market participants. To be sure, here comes the obligatory genuflection to Wharton. To be sure, some academics, mostly finance professors, and a few intrepid, heterodox voices among central bank research staffs identified risks that might be building. But even they tended more to diagnosis and warning than to prescription. Thus, although major regulatory legislation is often, if not usually, preceded by long periods during which key ideas and proposals are circulated and discussed, Congress was writing on a mostly blank slate in crafting an immediate legislative response to the financial crisis. The necessarily somewhat extemporized character of Dodd-Frank has had several consequences for the development of financial stability regulation. First, many of the new authorities and requirements of Dodd-Frank require extensive elaboration through administrative rulemaking, frequently involving 3, 4, or even 5 regulatory agencies simultaneously. Second, the provisions of the law that use the concept of risk to financial stability as a directly applicable legal standard provide only general guidance for regulators in applying that standard. Third, broad as Dodd-Frank is in some respects, it does not grant direct regulatory authority in some areas that both academic and agency analysis suggest may pose systemic risks. Finally, in creating novel governmental entities and arrangements specifically designed to address financial stability, the law may raise some novel practical and administrative law issues. My remarks this afternoon address some aspects of the job of creating a financial stability regulatory system in light of these features of Dodd-Frank, and of the fact that theories of financial stability that might inform the fashioning of this system are in many respects still undeveloped or at the least contested. I'll begin with a brief survey of Dodd-Frank's financial stability provisions before turning to a few examples of this task of building a system for financial stability regulation. Dodd-Frank creates a legal and institutional framework within which financial stability regulation is to be developed. But with a couple of notable exceptions, it does not delineate the steps that should actually be taken to promote financial stability. A useful point of comparison is the Banking Act of 1933, which did not use the terms financial stability or systemic risk, but which specified the Glass-Steagall rule separating commercial from investment banking. It limited transactions of banks with their affiliates and established the Federal Deposit Insurance System to prevent banking runs and panics. While statutory modifications and considerable administrative implementation, of course, followed over the years, the key elements of the regulatory scheme for financial stability were contained within the original legislation itself. In contrast, there are relatively few Dodd-Frank provisions that more or less directly effect the policy changes intended to reduce risks to financial stability. Even the so-called Volcker Rule, which prohibits proprietary trading by banks, bank holding companies, and their affiliates, will require considerable regulatory build-out before its constraints become clear. At the risk of some oversimplification, one can classify most uses of the financial stability concept in Dodd-Frank into four categories. One, as a goal for a new regulatory authority. Two, as an instruction to government entities for ongoing analysis and monitoring. Three, as a directly applicable legal standard. And four, as a factor for consideration in decisions on applications for various proposed actions subject to regulatory approval. So now let me go through each of those somewhat briefly in turn. First, financial stability is used as a stated goal motivating a new regulatory or supervisory authority, without itself being the standard used in the realization of that authority. One important example here is contained within Section 165 of Dodd-Frank, which requires the Federal Reserve to establish a special set of prudential requirements for bank holding companies with more than $50 billion in assets, in order to, in the words of the statute, prevent or mitigate risks to the financial stability of the United States. Similarly, the far-reaching requirement in Title VII of Dodd-Frank that 5 federal financial regulators establish margin requirements for uncleared swaps written by swap dealers and other major market participants is intended to, again in the words of the statute, offset the greater risk to the dealers and the financial system arising from the use of uncleared swaps. The second use of financial stability as a concept in Dodd-Frank is that it takes a number of steps to enhance the capacity of the government to monitor and analyze threats to financial stability. Most prominent among these are the creation of the Financial Stability Oversight Council, or FSOC, and the Office of Financial Research. As I'll discuss in a moment, the FSOC as a collective entity has a limited, though important, direct regulatory role. Much of its time, however, will be spent fulfilling its mandate from Congress to assess risks to financial stability. The stated purpose of the Office of Financial Research is to support the FSOC and its member agencies through research, the collection and standardization of data, the development of tools for measuring and monitoring risk, and related activities. The third use of financial stability in Dodd-Frank is as a direct legal standard for the exercise of regulatory authority. And this is in contrast to my first category of Dodd-Frank provisions, which simply cite financial stability concerns as a motivation for a regulatory or supervisory program that is then developed with its own standards. To date, the most conspicuous type of this type of provision have been the authorities granted the FSOC to designate non-bank financial companies and financial market utilities as systemically important. The first of these authorities is directed at financial firms that are not bank holding companies, and thus not subject to capital requirements and other parts of the holding company regulatory regime. This authority is a direct response to experience in the financial crisis. During 2008, serious problems at AIG and at the 5 so-called freestanding investment banks, that is, firms that were not part of bank holding companies, contributed substantially to the severe stress in the financial system, with the failure of Lehman Brothers in September of that year igniting the most acute phase of the crisis. The standard to be applied by the FSOC is whether material financial distress at the U.S. non-bank financial company, or the nature, scope, size, scale, concentration, interconnectedness, or mix of the activities of the U.S. non-bank financial company could pose a threat to the financial stability of the United States. There follows a lengthy list of what are styled as considerations to be taken into account by the FSOC. However, particularly insofar as the last of these considerations is, quote, any other risk-related factors that the counsel deems appropriate, close quote, the list does not itself provide extensive guidance for the FSOC in applying the basic standard. Any companies that are so designated by the FSOC will be subject to supervision by the Federal Reserve, as well as to the special Section 165 prudential standards I mentioned earlier. To date, no firms have been designated, though the FSOC is actively considering possible designees now. Of course, the 5 previously freestanding investment banks have either been dismantled, as in the case of Lehman, converted into bank holding companies, as is true for Goldman Sachs and Morgan Stanley, or absorbed into an existing bank holding company, as is the case with Bear Stearns and Merrill Lynch. The other designation authority granted the FSOC is for financial market utilities, which are defined as multilateral transfer, clearing, or settlement systems for payments, securities, or other financial transactions among financial institutions. In July, the FSOC designated 8 financial market utilities as systemically important, and they are now subject to special risk management standards developed by the market regulators and the Federal Reserve. In addition to these designation authorities, Dodd-Frank grants the FSOC very broad scope for dealing with a large bank holding company or designated non-bank financial company that, again in the words of the statute, poses a grave threat to the financial stability of the United States. The fourth use of financial stability in Dodd-Frank is as a factor to be taken into account in various regulatory determinations. Most importantly, Dodd-Frank added the factor of risk to the stability of the U.S. banking or financial system to the non-exhaustive lists of factors set forth in the Bank Merger Act and the Bank Holding Company Act for consideration by banking regulators in evaluating a proposed merger or acquisition by a bank or bank holding company. However, the financial stability factor is not in itself dispositive, in contrast to the statutory provisions covering designation of systemically important institutions or special actions to address grave threats to financial stability. This brief review shows how ubiquitous the concepts of financial stability and systemic risk are in Dodd-Frank. The law creates or strengthens numerous forms of regulatory authority that can be used to control numerous practices or circumstances associated with financial instability. Yet the statute itself provides only limited guidance to regulators on how to implement financial stability where it is established as a standard, or how to weigh it against economic growth and other considerations where it is used as an informing concept for a regulatory exercise or a factor to be considered in regulatory approvals. Moreover, one does not really find in the statute or in its legislative history an implicit theory of financial stability from which to infer answers to the regulatory questions just noted. Indeed, Dodd-Frank directs regulation at a number of perceived vulnerabilities created by large financial firms in particular, and to some degree in the financial system as a whole. And thus, to the extent one can fairly induce an underlying principle, it is that the moral hazard associated with too-big-to-fail institutions should be counteracted in a variety of ways. This emphasis on too-big-to-fail institutions is both understandable and appropriate in light of the experiences of 2008, including the major injection of government capital into some of the nation's largest financial firms that fall. And in the absence of an informing grand unified theory of financial stability, it's hardly surprising, in light of the history to which I alluded earlier, that we haven't reached that end as of yet. Yet, much of the theoretical work of the last several years has suggested that financial instability is in important ways endogenous to the financial system, or at least to the kind of financial system that has developed in recent decades. Contributions to the literature by academics such as Marcus Brunemeyer, Gary Gorton, Perry Merling, Andrew Metrick, Hyun-Song Shin, Andre Schleifer, and Jean Tirole, although differing in some important specifics, all paint a picture of a financial system prone to instability for reasons in addition to and quite independent of classic too-big-to-fail concerns. Their various analyses suggest the possibility of destabilization even in a financial world with no dominant firms, but many medium-sized entities. This perspective focuses on one of the most important effects of the progressive integration of capital markets and conventional lending activities, something now popularly known as shadow banking. That is, credit intermediation involving maturity transformation and often significant leverage that is wholly or partly outside the traditional banking system. This intermediation depends critically on the creation of instruments that are thought to be safe and liquid, and as such, cash equivalents, similar in function to insured deposits in the commercial banking system. These instruments, much desired by certain kinds of investors, are short-term liabilities of the shadow banking intermediary, which backs them with a portfolio of long-term assets that, because of some combination of high diversification and low default risk, are expected to perform very well under nearly all circumstances, but carry significant tail risks that are not fully appreciated ex ante. A now notorious example of a shadow banking intermediary was the Special Instrument Vehicle, or SIV, sponsored by a financial firm. A SIV bought tranches of securitized mortgages with AAA credit ratings, which it financed through the issuance of short-term instruments that were regarded by investors as essentially a cash equivalent. But during the crisis, when tail risk materialized, investors came to understand that even the upper tranches of subprime and other mortgage securitizations might not be spared significant losses because of the dramatic fall in housing prices and the equally dramatic rise in defaults. A kind of run ensued as investors realized that their instruments were not truly equivalent to cash and refused to roll over their short-term funding of the shadow banking intermediary. Such SIVs are gone now, but other forms of shadow banking continue in such well-established forms as money market funds and repo markets. The vulnerability of shadow banking to runs as investors rapidly withdraw funding can lead to systemic problems as consequential as those associated with classic runs on traditional banks. If shadow banking intermediaries must rapidly liquidate longer-term assets that they can no longer fund, the impact extends across the financial system. The resulting declines in asset prices trigger margin calls on other investors, who may then need to delever by selling their own holdings, accelerating the fire sale of these and potentially other assets. In the worst case, the result can be the kind of generalized asset price decline and liquidity freeze observed at the height of the financial crisis. Dodd-Frank does include some significant provisions that, when implemented, could mitigate some of the risks associated with the shadow banking system and the potential for fire sales more generally. But Dodd-Frank does not fashion a far-reaching system of regulatory authority for the shadow banking system to parallel the one it creates for systemically important institutions. This is particularly noteworthy as there is clearly some potential for the new enhanced capital, liquidity, and other prudential requirements for bank holding companies to cause more activity to migrate to the shadow banking system. With this background, I'm going to turn now to a closer look at a couple of instances of the challenges both in elaborating the financial stability standards of Dodd-Frank with respect to systemically important institutions and in addressing the shadow banking system. As a prelude to this discussion, let me acknowledge that this is hardly the first time Congress has enacted intentionally protean statutory standards in response to a serious economic problem, and then relied on some combination of administrative regulation, law enforcement, and the courts to develop and adapt those standards as learning and experience grow. The antitrust laws provide a good example. The clause contract, combination, or conspiracy and restraint of trade that is so familiar to us today posed its own major challenge of interpretation immediately after passage of the Sherman Act in 1890. Indeed, in the first cases brought under Section 1, both the Justice Department and the Supreme Court came close to reasoning that a very broad range of contracts, by definition, restrained some trade and thus might be illegal. These interpretations were soon abandoned, but they stand as an admonition that early decisions under a new law can, in retrospect, look to have been somewhat makeshift. My first example of our current challenges is drawn from the Federal Reserve Board's experience in developing enhanced capital standards for bank holding companies with more than $50 billion in assets, as required by Section 165 of Dodd-Frank. As I noted a few moments ago, this is one of the Dodd-Frank provisions that establishes financial stability as its aim, but not as a direct statutory standard. Section 165 requires that the standards intended to prevent risks to financial stability increase in stringency based on the same non-exhaustive list of factors used for the designation of non-bank systemically important financial firms. In undertaking this task, we, meaning we at the Fed, began with the premise that a financial stability motivation for capital requirements is necessarily somewhat different from the institution-centered approach of traditional capital standards. Firm-centered requirements, that is, traditional capital standards, are informed by asking what level of capital would be necessary to allow a firm to remain a viable financial intermediary, even after absorbing losses that, within a fairly high level of confidence, might be encountered over some relevant time frame. The financial stability approach, on the other hand, begins from the fact that there would be very large negative externalities associated with the disorderly failure of any systemically important financial institution. Those costs would be distinct from the costs incurred by the firm itself and its stakeholders. The failure of such a firm, especially in a period of stress, significantly increases the chances that other financial firms will themselves experience great stress for two reasons. First, direct counterparty impacts can lead to a classic domino effect. Second, because losses in a tail event are much more likely to be correlated for firms deeply engaged in trading, structured products, and other capital market instruments, all such firms are vulnerable to accelerating losses as troubled firms sell their assets into a declining market. Thus, the aim of financial stability capital standards is to further reduce the probability that the firm might fail under stress through holding additional capital. In acting on this rationale for capital standards, we first sought to ensure that there would be an international initiative in the Basel Committee to develop financial stability capital standards for global systemically important financial institutions. Since the severe distress or failure of a foreign banking institution of broad scope and global reach could have effects on the U.S. financial system comparable to those caused by failure of a similar domestic firm. The task of determining how much additional capital is needed to reduce the chances of a systemically important firm's failure is not a straightforward one. Conceptually, there's a good starting point in what has been termed the expected impact approach, which calls for additional capital to reduce the probability of the firm's failure sufficiently to equalize the expected impact on the financial system of the failure of a systemically important firm on the one hand and the failure of a banking firm just outside systemic status on the other. But implementing this concept is complicated by the fact that despite some very useful metrics that have been developed in the last few years for measuring systemic risk associated with a particular firm, there is certainly no generally accepted approach. Each has its shortcomings as well as its merits. Thus, it is not realistic to think that at least in the foreseeable future, the concept of a capital surcharge precisely offsetting the systemic risk actually created by that firm can be achieved in practice. Indeed, differences among reasonable assumptions in applying the expected impact approach led to a fairly broad range of potential surcharges. The 1 percentage point to 2.5 percentage point surcharge amounts negotiated within the Basel Committee are at the low end of that range, reflecting a good deal of caution for this incipient process. Frankly, they reflect a bit more caution than I think would have been desirable, even given the uncertainties. The second interpretive challenge arises from the addition of a financial stability factor to the review conducted by the Federal Reserve Board of proposed mergers and acquisitions involving banks and bank holding companies. In some respects, this process resembles the pre-merger reviews conducted by the antitrust agencies under the Hart-Scott-Rodino Act. But the differences are also instructive. One is that under the Bank Holding Company Act, the impact of a transaction on financial stability is not itself dispositive. The board could approve an acquisition even if it determined that there was some adverse effect on financial stability, if and where it also determined that the transaction would produce benefits outweighing the financial stability concerns by, for example, increasing competition or efficiencies or public convenience. This balancing requirement contrasts with an antitrust pre-merger review in which the focus is solely on whether the transaction would substantially lessen competition. The statutory formulation in Dodd-Frank appears to reflect a congressional supposition that, like many social desiderata, the pursuit of financial stability may at times require trade-offs with other desirable aims. Another salient point of difference is that Hart-Scott-Rodino was not enacted until 1976, following more than 60 years of merger analysis by the antitrust agencies and merger jurisprudence by the courts. Indeed, the agencies had already published a set of merger guidelines in 1968. While the Antitrust Division or the Federal Trade Commission could and did begin pre-merger reviews with a well-developed analytic framework, there is no legacy of administrative or judicial analysis of the financial stability effects of mergers. We literally have had to start from scratch. Let me describe just a few of the conceptual and practical issues that may pose themselves. One is raised by the possibility that an acquisition may decrease the chances of material distress at a financial firm, while simultaneously increasing the potential negative externality on the financial system as a whole, should the firm nonetheless become seriously compromised. To borrow from credit risk terminology, the probability of default, or PD, may be reduced, but the loss given default, or LGD, may increase. You can imagine this circumstance where, for example, an acquisition would demonstrably reduce a firm's dependence on short-term wholesale funding by providing more deposits or other reliable funding sources. but where the firm's increased size and market connections would compound the damage to counterparties, intermediation, and asset markets in the event of unmanageable stress. In such a case, are risks to financial stability increased, unaffected on balance, or actually decreased? In theory, as is done in credit risk modeling to calculate capital needs, one could multiply PD by LGD to yield a single systemic financial risk number for both the status quo and the post-acquisition firm in order to determine, or at least create a presumption, of which outcome is preferable from a financial stability perspective. This would be the financial stability equivalent of the Herfindahl-Hirschman index that is so pervasive in antitrust. But we are still in the relatively early stages of exploring the utility of different approaches to measuring both these variables, and do not have a single well-established metric for either today. The second issue is time contingency. Consider an acquisition that in calm times seems pretty clearly to increase the systemic footprint of an already large interconnected acquiring institution without having a material positive effect on the resilience of that firm during a stress period. That starkly stated circumstance would seem a prototypical case in which a conclusion of an adverse effect on financial stability would be reached. But now suppose that the target firm is already under substantial pressure in an increasingly stressed financial environment, and that the potential acquirer appears relatively strong. A case could be made that allowing the acquisition in that circumstance would support financial stability by relieving funding and other counterparty pressures and forestalling distressed asset sales. Continuing my comparison to antitrust law, this outcome would be an analog to a failing firm defense. Of course, this was precisely the rationale in 2008 for the government not only permitting but encouraging J.P. Morgan's acquisition of Bear Stearns and Washington Mutual, Bank of America's acquisition of Merrill Lynch, and to some degree, Wells Fargo's acquisition of Wachovia Bank. The result is that the concentration at the top of the U.S. financial services industry is even greater than before the crisis. Allowing the acquisition I have hypothesized here could buy some immediate stabilization, but at the cost of arguably greater moral hazard and risks to financial stability over the medium term. A third kind of issue arises because of the transaction-driven nature of the Bank Holding Company Act merger review provisions. For example, suppose a large regional bank and a broker-dealer propose to merge. Standing alone, that transaction might well look to increase risks to financial stability, not only because of the initial combined size of the firm, but because the broker-dealer operation would presumably grow when affiliated with a larger commercial bank. But would prohibiting that transaction mean that the current group of very large integrated financial firms would have their market positions essentially protected by the financial stability considerations? Such an outcome would be ironic indeed. The Federal Reserve could, if it so chose, avail itself of the discretion to balance different effects by allowing the merger on pro-competition grounds. Whatever its decision, the Fed might effectively be determining broader issues of industry structure in the context of a single case. Yet even before this kind of balancing of positive and adverse effects was reached, there would surely be an argument that ensconcing the existing large integrated firms would itself increase risks to financial stability, since these firms, which, by the way, are each the product of prior mergers, might be the only ones capable of growing more in key parts of the financial services market. These three kinds of questions which I've just described underscore the difficulties entailed in anticipating the range of financial issues that may be presented in merger cases, and in trying to resolve the financial stability questions that have been anticipated solely through consideration of hypotheticals. This is one of the reasons the Federal Reserve decided not to develop and issue a rule or detailed guidance on the financial stability factor. There simply isn't the accumulation of experience and of thoughtful evaluation of these issues by people both in and out of government to inform something akin to the merger guidelines published by the antitrust agencies. Accordingly, the Fed is taking very much of a case-by-case approach to these reviews. I would expect that over time, our discussion of relevant factors in the context of specific transactions will provide firms, their attorneys, and the public with more guidance as to how a specific case is likely to be analyzed. And at some point, we and others in the official sector may become comfortable with a particular measure of systemic risk to be the starting point for analysis. But I suspect it will be much longer, if ever, before such a measure could provide the extent of presumptive sorting that HHI does in antitrust today. While the absence of experience and a comprehensive informing theory make detailed guidance infeasible in the foreseeable future, I do think we should be able to elaborate certain categories of presumptive approvals and denials more quickly. Before I suggest how, let me emphasize that here I am speaking for myself only, since the full board will address these issues only in future orders. We have already suggested a limited presumptive safe harbor, where an acquisition involves less than $2 billion in assets or results in a firm with less than $25 billion in assets. Personally, I would set the size of the resulting firm higher than $25 billion, but somewhat lower than the $50 billion Dodd-Frank threshold. At the other end of the spectrum, I would urge a strong, though not irrebuttable, presumption of denial for any acquisition by any firm that falls in the higher end of the list of global systemically important banks developed by the Basel Committee for purposes of those capital surcharges I described earlier. Firms at the lower end of the Basel Committee list, or that may later be designated by U.S. authorities as domestic systemically important banks, might have a slightly less robust but still significant presumption against acquisitions. And there could be exceptions here for de minimis acquisitions or in cases where dispositions were judged to offset any increase in systemic risk from the proposed new acquisitions. It's reasonable to ask why these negative presumptions are appropriate, given my general review that the absence of both experience and consensus theory make a case-by-case approach necessary. One answer is that notwithstanding the fact that analytic tools for assessing a firm's systemic footprint are in a relatively early stage of development, everything we do know suggests that the firms on the Basel Committee list strongly implicate the kinds of systemic considerations mentioned by Congress. Second, it does seem incumbent on us to provide at least some guidance to firms where we can. And a third answer is that once an acquisition is consummated, Dodd-Frank provides only narrow authority to order divestiture on financial stability grounds. Though the board can recommend action by the FSOC, as I mentioned earlier, I've already noted that the test here is a grave threat to financial stability, presumably a significantly higher standard than the risk to financial stability that can constitute an adverse effect for purposes of the Bank Holding Company Act. As you know, Section 7 of the Clayton Act permits the antitrust authorities either to restrain a merger beforehand or undo it thereafter. But the Federal Reserve's authority to disallow the merger on financial stability grounds appears to lapse after the merger is completed, but for that narrow FSOC authority. This circumstance suggests an additional measure of caution by the Federal Reserve in considering acquisitions by firms that can reasonably be expected to raise significant financial stability concerns. Abstracting a bit from what I've said to this point, I can say that for all the attention paid to financial stability analysis in the last few years, relatively speaking, it's still a fledgling enterprise. But while the absence of well-established systemic risk measures may counsel caution in approaching merger analysis, and while it has surely affected the formulation of those systemic risk capital surcharges, this cautious approach may well be leaving a gap in financial stability regulation. One of the difficulties in building out a financial stability analysis is the absence of an upper bound point of reference. There is no statutory basis for identifying a certain systemic footprint above which the risks to financial stability are not worth bearing compared to whatever possible benefits may be associated with the operation of the largest, most interconnected firms. Similarly, The absence in the financial stability area of the equivalent of the monopolization provision in Sherman Act Section 2 to complement the merger provisions in Clayton Act Section 7 creates an anomalous regulatory feature. It means that the current structure for financial stability regulation permits substantial increases in systemic risk by an institution so long as it is generated from internal growth. To the extent that a growing systemic footprint increases perceptions of at least some residual too-big-to-fail quality in such a firm, there may be funding advantages for the firm which will in turn reinforce the impulse to grow. There is then a case to be made for applying an upper bound. In these circumstances, however, with the potentially important consequences of such an upper bound and of the need to balance different interests and social goals, it would be most appropriate for Congress to legislate on the subject. If it chooses to do so, there would be merit in its adopting a simpler policy instrument rather than relying on indirect, incomplete policy measures such as administrative calculation of potentially complex financial stability footprints. The idea along these lines that seems to have the most promise would limit the non-deposit liabilities of financial firms to a specified percentage of U.S. gross domestic product, as calculated on a lagged average basis. In addition to the virtue of simplicity, this approach has the advantage of tying the limitation on growth of financial firms to the growth of the national economy and its capacity to absorb losses, as well as to the extent of a firm's dependence on funding from sources other than the stable base of deposits. Of course, the difficult question would be the applicable percentage of GDP. And there would also need to be judgments on a number of secondary issues involved in calculating these ratios. Even good answers to all these questions would produce a policy instrument that could seem excessively blunt to some. But this is a debate well worth having. Now, having just a few months ago devoted an entire speech to the shadow banking system, I wanted to spend most of my time today on the interpretive issues that I've just discussed. But to give a sense of the complementary regulatory challenges in dealing with the shadow banking system, let me just briefly describe one specific current issue and mention a broader concern before closing. The specific issue is that of money market funds. As many of us in the government have pointed out, money market funds remain a major part of the shadow banking system and a key potential systemic risk even in the post-crisis financial environment. The industry's survival in its present form is likely due in no small part to the unprecedented interventions by the Treasury Department and the Federal Reserve in providing insurance and liquidity support respectively to the industry in response to the run prompted by the failure of the Reserve Primary Fund in 2008. The interesting point here is that a regulatory agency, the SEC, has ample regulatory authority to address the systemic risk problem. Indeed, the legality of money market funds continuing to publish a fixed net asset value of $1 per share, even as the actual value of the underlying assets varies within a modest range, is itself the consequence of the SEC's Rule 2a-7, which exempts money market funds from the general requirement of floating NAV applicable to open-ended mutual funds. In amending its rules in 2010, the SEC took some good first steps to improve the resilience of money market funds. But many, including Chairman Shapiro, do not believe these are sufficient to mitigate the run potential in money market funds. Unfortunately, a majority of the current SEC commissioners has to this point been opposed to moving forward with the reform measures Chairman Shapiro has proposed. The question then is how the FSOC and its other member agencies should proceed, given that the SEC has heretofore declined to act. The FSOC has only the limited authority to present an agency with recommendations for action and the right to receive an explanation should the agency not accept those recommendations. As you may have seen, 2 weeks ago, Secretary Geithner sent a letter to the members of the FSOC in his capacity as its chair, in which he urged the Council to use its authority under Section 120 of Dodd-Frank and to consider alternative actions to reduce the structural vulnerabilities associated with money market funds. In the event that the SEC is unwilling to act in a timely manner. These alternatives could include FSOC designation of money market funds as systemically important. They could also include action by FSOC member agencies, such as the bank regulatory agencies imposing restrictions on regulated financial institutions' ability to sponsor, borrow from, invest in, or provide credit to money market funds that do not have structural protections. From my perspective, at least, each of the options open to FSOC and the rest of its constituent agencies is decidedly a second-best alternative as compared to a change in SEC rules to remove the fixed net asset value exception, to require a capital buffer that would staunch or buffer runs, or measures of similar effect. And when I say second best here, I mean to include for the funds themselves. The protective tools available to the rest of us do not fit the problem precisely, and thus will not regulate at the least cost to the funds while still mitigating financial risk. But that is the legal situation we all confront. My hope, of course, is that recent indications that other SEC commissioners are now willing to move forward with reforms will lead to the SEC adopting first best measures in the near term. The money market fund example is noteworthy, in substantial part because of these interesting institutional issues. More generally, though, the capacity of private financial market actors to create what are, at least in normal times, considered cash equivalents raises broader financial stability questions. Specifically, there may be need for new macroprudential instruments, such as comprehensive authority to impose margins on all cash-like instruments, regardless of whether a firm creating them is a regulated entity, such as a bank holding company. Such possibilities obviously carry significant consequences, not just for the liquidity available to the financial system, but also for values such as the concentration of government authority. This is a topic on which much further thought is needed. In concluding, let me say that it may not always be the case that the most interesting time to be involved in a regulatory area is at its early stages. But I am reasonably certain that this rule of thumb applies to the formation of a system for the regulation of systemic risk. From the standpoint of a regulator, the key challenge in these early stages is to be neither excessively self-confident about what we know about financial stability, so as to produce unfortunate unintended consequences, nor excessively tentative, so as to fail to take steps to counter the very real risks that do exist in keeping with the aims stated by Congress. And I want to make one final reference to antitrust law. As you probably know, the evolution of antitrust in recent decades was heavily influenced by the work of academics, specifically law professors and industrial organization economists. That was due in part, I think, to the practice of the Antitrust Division of the Justice Department and the Competition Bureau of the Federal Trade Commission, recruiting so many present and future academics to work in those agencies for a few years. Indeed, quite a few heads of the Antitrust Division and the FTC were themselves academics, often law professors. The result was a cross-pollination of theoretical advances and institutionally grounded knowledge that is unusual, if not unique, in regulatory areas. While it may be difficult to replicate this pattern in the nascent field of financial stability regulation, there is ample room and need for some version of this cross-pollination. Issues such as those I have discussed today can only profit from an academic perspective, informed by practical and institutional considerations. Obviously, I'm standing this afternoon in front of an almost ideal audience to provide that perspective, and I look forward to hearing your lectures in the future. Thank you very much.
So I'm going to take the co-director's privilege of asking the first question. Now, let me offer a three-sentence summary of your talk and see what the reaction is. All right. So Dodd-Frank is this massive statute that takes the classic strategy, follows the classic strategy of broad drafting, delegating authority to implementing agencies, which will be stocked with experts, which will figure out the more particular regulatory strategy. But in this case, that is not working because we do not have the technologies to permit nuanced implementation. Therefore, we should freeze industry structure more or less where it is today, and look towards some rough-out rules in lieu of more nuanced regulation. Okay? If that's fair, do we have the institutional and political wherewithal to succeed with your suggested course in lieu of the appearance of nuanced regulation?
So I don't think, Bill, that's I would have, in writing the abstract for the lecture, I would have differed slightly. I hope I'm not heard to be saying that I would freeze industry structure where it is today, or that that's an inevitable consequence of the kind of case-by-case approach I've suggested. I was trying to pose that one hypothetical as an example of where industry structure could inevitably be placed in front of us, and whichever way we decided was going to have an impact. I'm quite confident that the board will decide as best it can any cases brought before it. I'd also say that the absence of the consensus informing theory of financial instability does not mean we're not making progress. I mean, I think we've done a lot. We continue to do a lot. But what I think it does tell us is there's going to be necessarily a continued process of learning and perhaps modifying steps, not just the Fed, but all the relevant agencies are taking. And that is likely to continue, I think, for some time to come. That's one of the reasons why I invite the sort of academic and agency interaction, because I think that might accelerate the period which we all may be able to sit back and say, okay, things are still going to be interesting and evolving, but at least now we have some roughly shared understanding of the financial stability regulatory premises, assumptions, and principles, with the classic, points of contention that people can focus on. So what I was trying to suggest was that we are going step by step, and that's going to perhaps be a little frustrating for people, but there isn't that immediately implementable architecture. And then in noting the absence of an upper bound, I was suggesting that at some level, the balancing between systemic risk, or increased systemic risk, certainly for very largest institutions, and what the social utility that may come from the activities of these very large, very integrated corporations, financial firms, that the absence of that upper bound is something that makes the systemic risk surcharge and the merger consideration more difficult for us, because it is, again, unlike Section 2, which is sort of a baseline against which you can think about Section 7, there's not that kind of complementary message from Congress that here or under these circumstances it's too much. But I also want to suggest that Congress is probably, or almost surely, the right entity to make that judgment, precisely because there is some trade-off. Now, if Congress chooses not to go down that road or goes down another road, we'll continue to do the best that we can, going forward, case by case, doing the analysis as best we can, informed by everybody within and without the government. But in suggesting a couple of things that Dodd-Frank doesn't do, was trying to imply, at least, that we could have a greater sense of boundedness for the regulatory agencies with that kind of provision, not at all downplaying the difficulties in an agreement on that provision. That is, I can imagine you could get a bunch of people in a room who would say, Yeah, that's, if you're going to do something like that, it may be a little blunt, but there's a certain virtue to simplicity. But now, what should the percentage be? And their disagreement might break down. But I do think it's a debate very much worth having.
Paul Hager.
Thank you, and thanks for your excellent comments. I'm sure you remember the history of Dodd-Frank as legislation. It really started off with some very specific prescriptions, and I think the success in lobbying on the bill was really to live to fight another day and to move it to the agencies and provide some directions to the agencies. But if you could comment on this, the financial stability provision, while it has the benefit of a lot of flexibility in rulemaking, would be almost impossible to challenge a rule based on that. And I know before I retired recently, I was in the mutual fund industry, and when we kept coming forward to the SEC staff with different ideas about money fund regulation, including in 2010, which we thought they had accepted and was enough, and they kept rejecting them on the basis that we couldn't guarantee that there would never be a run, which nobody can ever guarantee. So I just wonder if you have comments on the possibility that the financial stability standard could create an imperial bureaucracy because it leaves rules unchallengeable because it's so unspecific.
I guess I don't see any reason why rules in the financial stability arena should be or are any less challengeable than those in other areas of economic regulation. Certainly, I mean, my observation has been that the various parts of the industry regulated by the SEC have never been shy about challenging rules. I think, just as with any broadly stated statutory standard that needs to be elaborated, you're going to have you do have a responsibility on the part of the agency to articulate as best it can the rationale for the interpretation that it's chosen, and then a court has the ability to and will, in appropriate circumstances, decide whether that is out of bounds or not out of bounds. I think that we're at way too early a stage to make a judgment as to how the institutional relationships are going to work out here. I mean institutional relationships among the various agencies that are doing the rulemaking. We have a better sense of that. How the FSOC is going to evolve, but also what the relationship with the judiciary may be over time. I mean, a firm that is designated by the FSOC can challenge that determination, and presumably the courts reviewing that determination will bring to bear the same kind of judicial review that they've brought to bear on the FTC if it's making a judgment on mergers or on consumer protection or any number of other grounds. So I don't actually see anything systematically different here from other areas, except for something which I don't actually think affects the reviewability much, and that is, as I said earlier, that because of the fact that systemic risk was discounted by so many in government, in academia, in the industry for so long, there wasn't the gestation of a set of reform ideas that then got talked back and forth and kind of got grounded in a theory which maybe not everybody agreed with, but enough people to command a rough majority in getting something passed and then implemented. And I do think that is a difference from a lot of other regulatory statutes that we can think of where there's not perfect coherence because the nature of the legislative process is to pace some things in and to compromise, but where there's at least a basic theoretical framework which you can see through the statute. And that I think is harder to see here, except for that principle of manifold responses too big to fail.
Ed Rock.
You do a great job articulating and describing the complexity and the uncertainty, both theoretical and factual. And I'm curious, in light of all of that, where you come down on the use of what is maybe the simplest policy instrument, namely capital requirements. Why not raise capital requirements to 20 or 25% Tier 1 capital? There's an interesting academic literature from eminent finance professors pointing out that the benefits are to stability of high capital requirements would be clear, and the costs would be probably very modest because of offsetting. If you get the capital too high, the debt is going to be, you're going to save money on what you have to pay on your debt. So that why not proceed with a very simple policy instrument, namely 25% capital requirements or 20%?
So I think I would slightly disagree with your premise that there's widespread agreement among academics on the capital. And in fact, I guess I would say that was a minority view that you just articulated, and most people in finance would still say that there are non-trivial costs, opportunity costs associated with higher capital levels. There has surely been a very interesting debate on Modigliani Miller that has proceeded as a result of these suggestions. Now, I've definitely been a capital partisan. The book to which Bill alluded was basically a plea for higher capital and different modes of calculating capital, because that's part of the game as well, of course. What's the numerator and what's the denominator? I've said this before publicly, so I don't mind repeating it again. My own view is that Basel III capital standards were a little bit lower than I would have liked to see them. As I said, the systemic risk capital charges that were agreed upon were at what I would describe as at the low end of the permissible range. One alternative to the kind of upper bound definition would be a steeply progressive capital charge that would be imposed at some point along the spectrum of systemic risk measurement. I think that doesn't actually fundamentally change the social utility analysis that I was suggesting earlier. That is, one might say that an economist might prefer the steeply progressive capital charge rather than something that looks like a quantitative restriction, because you allow a firm to say, notwithstanding a 20% capital charge above this level, we still think this activity is worth it. Although I have to say, as a financial regulator, I would like to see what that activity would be, what the beta is on it. But I think if you're going to do that, as is the case where there's equivalence between a theoretical quantitative restriction and a theoretical taxing regime, you're still making a set of social trade-offs. And the point I was trying to make was, I think at some level, those are not reducible to a formula that everybody can agree on. That whether in fact we should forego possible benefits from very large, very interconnected entities in order to buy more financial stability doesn't seem to me the kind of decision that is optimal for regulators to make, although regulators will make them if that's the default position that Congress has chosen. But I guess my core answer to your question would be, I don't actually think that process is different whether one is doing it with steeply progressive capital charges or a ceiling on, a presumptive ceiling on assets, or, for example, as others have suggested, a tax on non-deposit liabilities. There are many ways you can achieve the same end, but I think you still have to have the debate, and the debate involves values, benefits, costs that are not, strictly speaking, comparable. They can't be netted out, I guess is what I'd say. Having said all that, I need to finish again by saying I do wish capital were somewhat higher.
One last question from Gideon Parchamovsky.
Thank you very much.
Make it a short one.
Yeah, very short. Thank you so much. Thank you very much for a wonderful talk. And I really enjoyed it and learned a lot from it. And frankly, I would not want to trade places with you. But here is my, maybe residual concern. Maybe it's not so residual. So there's the saying that we're always regulating or solving a crisis after it occurred, after it's behind us. And naturally, there's a learning curve. You want to have information. You want to adopt a reasonable approach. But at the same time, economic conditions keep changing all the time. So how do you know that by the time that you arrive at all the information you need and you feel that you're ready to take action, the action you will be taking will not cause potentially more harm than benefit to society?
So that's the...
Is that a short question? I don't know.
I bet there's a long answer.
That's a question, again, that's a question I think which could inform regulation in any dynamic area of the economy or subpart of the economy. So just a couple of observations maybe. I think one observation is that the comments I made about shadow banking and the potential endogeneity of financial instability seem to me just as salient now as they were pre-crisis, even though the forms of shadow banking have shifted somewhat. And so I don't think this is the classic case of fighting the last war, but instead trying to understand the new terrain on which everybody is meeting one another. Second, a byproduct of this kind of case-by-case approach or regulation-by-regulation approach that I described is that there is a whole lot of time to think about and to consider unintended consequences. And while generally I think we'd all prefer if we could get through the regulations, read all the comments, revise them, get them done, get them out of the way, the length of time it's taken to do all the regs has actually given the staffs at the regulatory agencies substantial opportunity to see how the various parts of the financial services industry are changing, how the market has changed as a result of the crisis, as well as, I think we've got to be honest about this, anticipation of new regulatory systems that will be in place. So I think there's an interesting iterative process between watching what's happening out there on the one hand, and on the other hand, trying to think not in terms of the last war, although that saying can sometimes go too far. If people say, well, don't fight the last war, but if they mean by don't fighting the last war, don't erect the defenses that you should have had before, the enemy is just going to go after the same vulnerabilities in the future. So you both need to deal with the vulnerabilities you had before and then try to be a bit dynamic. The last thing I'd say here is financial regulation is different from most, if not all, other areas of economic regulation in a number of particulars, but one that's brought home to me every day, and that is the importance of the supervisory process. If you think about environmental regulation or securities regulation or a lot of other areas, it's basically a compliance, regulatory, enforcement type of mechanism. The SEC does not have people sitting on trading floors making judgments. The EPA doesn't have people sitting in big companies going over their plans with them, although I guess in negotiated rulemaking there is a bit of that. But with supervision, as people may or may not know, we, the OCC, the FDIC, have on-site examiners, and then we have many experts, sitting down here on the Federal Reserve Bank of Philadelphia, Federal Reserve Bank of New York, the board in Washington, who are in a constant supervisory dialogue with those whom they supervise. Now, that gives a form of information, and with the right kind of monitoring and metrics, an ability to see trends as they develop. And as I've said to examination or supervisory teams, ask the people at the bank how they think they're going to make their money, and that'll tell us what we have to watch. See what asset classes are growing quickly, see where there's new leverage. We can do a bunch of that in a way that relying on data, published data, would never let you do. There's a bit of a problem with the supervision, because, or perception of supervision, because sometimes people think, well, you've got these 35 people sitting in this big bank, you should know everything that's going on. And, you know, as I pointed out, the big banks have 100,000 employees, and we've got 35 guys there, and the OCC has another 25, and the FDIC has a half a dozen. We're outnumbered in that sense, so we can't possibly know everything that's going on, and that shouldn't be the role of supervisors. But we can get a somewhat better internal sense of what the firm is doing, what its risk profiles are, what its risk management is. And if we're alert to that, and if we supplement that with horizontal, quantitative assessments of the industry as a whole, I think we can guard against a little bit of this backward-looking grand creation problem and make sure that we're adapting ourselves and the regulations to what we need to do in the future.
Please join us at a reception in the Great Hall and thanking Governor Tarullo.